Well, we just saw the defense asked for a third time for a mistrial in the Kim Potter case, and for the third time, Judge Regina Chu has denied them. So in the big picture, this is day 9 of testimony, and it ended at 12:45. The prosecution had 25 witnesses that they put on the stand, and the defense had 8 witnesses. Of course, the most important of those, Kim Potter herself. Now, 7 men and 7 women will deliberate this case. Juror number 57 and number 58, the alternates have been removed from the case. One of those jurors we believe to be a white woman who was in her 70s. She's one of the alternates, the oldest member of the jury. She will not be part of this deliberation. And the other one is a white man in his 30s. He was the other alternate. He will not be part of this deliberation. So, Joe, we want to get any final word. They're going to take a look at this laptop and see what it has on it. But I guess I want to start with some bigger issues, but let's start with the mistrial. Does the defense have any ground to stand on that, hey, this wasn't brief and it wasn't concise and you went way outside the scope of rebutting what I said?
They didn't have a chance at a mistrial motion because just because the prosecutor went far afield of your regular rebuttal doesn't mean you're going to automatically get a mistrial. I mean, it was quite obvious that it was sort of a second closing argument, but they were never going to get a mistrial.
Yeah, he did. You know, there's some points there. I didn't think he was making a lot of good points, and then at the end, I thought Matthew Frank made a number of them. I don't want to start dissecting everything, and I want to play some important parts back for people who are watching and want to get your analysis on that, and I'm eager to hear it as well. But I'm hesitant to start this while they are still here in court, and they might have some issues to bring up with one another. So in general, what do you think of Matthew Frank's rebuttal and how he was trying to frame this for the jury?
Well, what was amazing is that both sides are getting the issue of superseding incorrect. I was pretty amazed at that. Mr. Gray and Mr. Frank, they weren't getting the right meaning of superseding. Superseding cause
let's listen in, Joe. Hang on.
Playback equipment.
Yes, we have reviewed the computer. We're satisfied.
Okay. All right. The reason that's important is because the laptop will be provided to they provided the laptop. It'll be given back to them. It won't be part of the record on appeal. And that's why it's important for the defense to be assured that there's nothing inappropriate on it. Okay. Is there anything else that we need to put on the record? Yes?
Are we expected to stay here till 6 o'clock?
I am going to let the jury deliberate until 6.
Okay. So that means we have to be in the room.
Yes. Okay, anything else? All right, counsel, thank you.
Okay, so important to know, the jury can deliberate until 6 p.m. Tonight. And Joe, we'll get to superseding in a second. They can set their own hours, right? If they don't want to start till 10 in the morning, they can start at 10. They can start at 7. They give us the rules around deliberation and how the jury determines what they want to do.
The judge will basically give them guidelines. She'll ask, do you want to start at 9 and go to 5 or 6? But if the jury says, we're hard at work, we don't want to end till 9 o'clock tonight, they can do so, and most judges will follow their lead.
And I didn't hear the word sequestered unless I missed it, but they are, Joe. I mean, now they're just with one another, staying in a hotel, not going home at night, not getting access to phone, internet, things like that, correct?
That's correct. They decided that early on in the trial that the jury would be sequestered once they start deliberations.
Okay, now let's go back to this concept, this argument of superseding, because that has to do with Dante Wright's behavior and actions. And you explain, well, go ahead. You think they both got it wrong.
They did. Superseding is a cause that replaces, supplants the original cause. So, for instance, if Ms. Potter, say, shot Mr. Wright in the abdomen, but he could have lived for quite a while, but right after she shot him, some other officer shot Mr. Wright in the head, which ultimately killed him. That second shot in the head would have been a superseding cause. But neither side explained that. Mr. Gray was saying, well, his running away or fleeing was a superseding cause. And Mr. Frank was saying, well, Dante Wright, whatever he did, he must have done something after in order for it to be a superseding cause, as if it was some type of self-harm. So both sides really did not handle the superseding cause correctly. And obviously, we saw at the end, the judge just said, well, the instruction on superseding is in the jury instruction packet, so they'll have to deal with it.
Well, I speak to that a little bit because we talked about this many days ago. This is day 9 of testimony. Confusion tends to help the defense, right? I mean, you can't get this clear view that I know exactly what she did when you're confused, correct?
That's correct. The defense seemed to stress that everything's about causation, and after that, accident, which was a little perplexing because this case is really about accident. And the state seemed to follow that road and say, well, if it is causation, Dante Wright didn't do anything to himself after the shooting. Well, it's not really about that. A superseding cause is some other factor that comes to play after the shooting, and that wasn't the case here. So you're right. This is very confusing. Both sides have left the jury with confusion. We'll see to whose benefit it winds up helping.
Yeah, well, to that point, let's play this soundbite from Matthew Frank talking about how the jury should perceive a mistake. And this was interesting as well.
My review of the video, you rely on your own review of the video, that she has her gun in her hand, pulled out of the taser for some 7 seconds. Somewhere between 5 and 6 of those seconds, she has it held out in front of her. And then she shot Mr. Wright in the chest from a foot or 2 away. There's no mistake defense. You will not see an instruction on the defense of mistake. The judge will not give you an instruction that says a person is not guilty if they commit a mistake. That's not the law, no matter how often the defense says mistake.
Effective, Joe?
Partly because it's the way it should have been done is running through exactly what the experts said. I mean, both sides really didn't utilize their experts' testimony. Normally, when you have an expert, you run through, here's why it wasn't a mistake, X, Y, Z. Remember what our experts said about this, how they discredited the other expert. And then the defense does the same. With this, it's basically, well, she should have noticed she had a gun in her hand. Well, remember what one of the experts said, sometimes you have tunnel vision and you're focused, laser focused on something else. So yes, I think it was partly effective, but really both sides failed to utilize their own experts.
And that gets into this confusion issue because the prosecution's main expert, their expert on the use of deadly force, was on the stand and he said, oh, clearly she intended to use her taser. This was a mistake. And we saw jury members writing that down in their notepad. And now they come back later and say, but there's no law about mistakes. So again, it just leads to this confusion part. But let me move ahead to something else because I was I was so surprised that Matthew Frank brought this up, talking about assaulting the officers and Dante Wright's behavior. Let's play that and then I'll ask you specifically about it.
You look at the videos. You believe your eyes. Look at the videos. Watch them in real time. That's fine. I encourage you to do that. We slowed them down so you could understand what's happening there. But sure, watch them in your own time. I agree with that. But you can believe what you see in those videos. What you see in those videos is Dante Wright never assaulted these officers. The characterization of fighting and struggling is not supported by the evidence. Those are just terms used. Not supported by the evidence. He was trying to flee, no doubt about it. But he was not struggling or fighting with these officers. He simply pulled away, tried to operate the car. He never even threatened the officers.
I was so surprised he brought up those 2 points. One, watch it in real time, because in real time, you realize things happen quickly. The whole thing went down in 13 seconds. And I guess he wants to use the term pulling away, not struggling. Wasn't Dante Wright struggling to get away? I mean, granted, he didn't throw a punch, but I just was surprised he conceded both of those points, Joe. I mean, there was a struggle. Are we not fair to say that?
It's completely fair to say that. And this is, once again, just like the term superseding, words matter. And it's up to the attorneys to make sure, quite frankly, that they know the meaning of the words that they are using. And when you say there is not a struggle, well, there clearly was a struggle. When you say there was no assault, that's correct. No one threw a punch. Mr. Wright didn't try to scratch, kick, punch, anything like that against the officers. But really, when you're in a case like this of, great importance, you've got to know the meaning to the words you use.
Yeah, I thought the same thing. Because Frank is so smart and so measured, I was just surprised that happened. And these folks are, it says everyone bring your own experience. I mean, people know what a struggle is, and you can then use as many adjectives. Yeah, there was no throwing of the punch, there was no kicking, there was no spitting. But, this young man was struggling to get away. It just seemed a little strange. And then he went on later. He said, would I have preferred Dante Wright followed commands? Yes, but does that allow him to be shot to death? It does not. Can we accept the fact that anyone who doesn't meticulously follow orders can be shot? He said that's absurd, which gets us all to this reasonable force. And I think, Joe, do you think in the jury's mind this concept of where Sergeant Johnson was, how afraid he was, how Kim Potter perceived Sergeant Johnson, and what a reasonable officer would have done in her circumstance is going to be like a real inflection point on their deliberation?
Yes, because when you look at those jury instructions, it's all about what would a reasonable police officer do in Ms. Potter's situation. So that's what it comes down to. But the interesting thing that's going to happen in the jury room is, and I would love to know this, maybe we'll find out after, how many times is that jury going to play the video? I was very surprised that both sides agreed that the jury can simply have these videos with a laptop and play them at will. Almost every other single time. When a jury wants to review a video, review an audio, they must come back into the courtroom with the parties there, on the record, remain silent, and then the bailiff or one of the attorneys plays the video. And then the jury goes back into their deliberation room. But when you give a video or an audio to a jury and say, here are the means to play it, you have no idea what they're going to do with it. They could break it down frame by frame or review it 1,000 times.
Oh, that's fascinating. I just kind of thought that once everything was in court and on the record that they had access to it. So you can make motions not to give them access? That would have been a point the judge would have had a rule on?
Absolutely, and most of the time, 95, maybe even more % of the time, unless there's something unusual, when a jury wants to see a video again, they ask to see it, you bring them back in the courtroom, the judge allows both sides to make their objections. Prosecution or defense may not want to have the jury review it again. But in this case, it seems both sides have agreed to just give them the videos and let them play them at will. Quite unusual.
Yeah, and of course, the defense said you need to play it at full speed because, I mean, again, it happens in 13 seconds. That's why I couldn't believe that Matthew Frank said, yeah, that's the best idea, play it at full speed. But we'll see. And again, we don't know what they're doing back there. I thought Matthew Frank, though, really brought some clarity for the jury at the end, talking about the difference between murder and manslaughter. And let's review that, Joe.
In murder, the actor intends the death. In manslaughter, which is based on recklessness, the person does not intend the final result, the death. Rather, their liability, as I said, is based on recklessness. Their conduct creates a risk that they disregard, and somebody dies.
He made it clear to him, right? I mean, that makes sense. That's easy to understand.
Yes, that was good to differentiate what an actual intentional murder is like and what a manslaughter is like. And it's very true. A manslaughter does not have the intent to kill. So it was good to differentiate those laws.
Joe, we mentioned this before. I want people to know the laws changed in Minnesota. Every state has their own law. Years ago, and I don't know what year, maybe you remember, the defense had the final word, right? Because the concept was, hey, we're going up the powerful state and the power of the entire government to charge an individual, so the defense should get the last word. And then all of that changed at some point in Minnesota, and now the prosecution gets the final word. Kind of explain the genesis or the evolution of that, but more importantly, how important is that when we give the cliche, I want the final word, or I got the final word?
Based on human nature, it's important to have the final word. It always gives you a leg up. When I first started in 1989, the defense had the final word. And then in the early 90s, don't quote me on the year, but it was before, say, 1995 or 96, it switched over that the state would get the final word. And the genesis for that, or the reason for that, is the following. In almost all venues, whether it's civil or criminal in most states, the party that has the burden of proof, that's the burden to convince the jury that they've proven their case, gets the final word. So that was the basis for changing it.
Interesting. Joe, I don't want to bore people to tears here, but let them know who's doing this. So there's 7 men and 7 women, and I'm not going to give these by number because we never want to be able to have folks connect who's who. But there's a white man in his 50s. He's a medical editor. There's a white woman in her 60s. She is a retired teacher. There's a white man in his 20s who is a member of a band and works in retail. There's an Asian woman in her 40s who all we know is that she works in Minneapolis. There's a white woman in her 20s who's a recent graduate of school. There's a black woman in her 30s who is a teacher. There's a white man in his 40s, and that's all we know. There's another white man in his 60s who is a registered nurse. There's an Asian woman in her 20s who is a student. There's a white man in his 40s who works in IT. And there's a white woman in her 40s who works as a project manager in IT. And then finally, a white man in his 50s who works as a youth coach. So, Joe, minority representation would be the 2 Asian women and the 1 black woman. And then we have the genders equally divided. And why people might not think that's a diverse group of jurors, you put some perspective on that when you kind of talked about our general Hennepin County population.
That's correct, because out of the 12 jurors, we have 3 who are people of color, so that's 25% of the jury. And in Hennepin County, we have approximately 80% of the people are white. So that pretty much goes to what the demographics of the county would be. But having 3 people of color out of 12 is obviously more diverse than having just 1 person. So it pretty much matches up with the demographics of the county. And remember, this is based on a county case. It's not just a city of Minneapolis. You draw from the whole of Hennepin County.
So they have to pick a jury foreman or a jury foreperson, we should call it, and then that person kind of leads things. I'd imagine, they probably want to use the restroom and eat lunch, and then they'll jump into it.
That's correct. They can decide what they do. Most juries pick a foreperson first so that they could have some order. The foreperson calls votes and proceeds as if, they're basically just giving a schedule to the jury and deciding on things as to, well, let's have a vote on lunch, let's have a vote when we should take a break, things like that.
Anything that we should be asking you that I haven't thought of, Joe, in regards to what happened today or the bigger picture?
Yes, the judge mentioned that if the jury wanted to hear or have read back a certain witness's testimony, they may ask, and they may ask questions about other things. And so it's not that that's unusual, but sometimes when you tell the jury that ahead of time, they do have questions and they ask to hear certain testimony again. I don't know how they will all handle that, but if the jury has questions, I would imagine they'd have those or present those by the end of the day. Yeah. So that's what I'd look out for.
Okay, yeah, because they don't have a written transcript of everyone's testimony, exactly what they said and how they said it. So, and that's sometimes a bit of a tell, right, depending on whose testimony they ask to review?
Yes, if all of a sudden a couple hours from now they say, could you please examine or could you give us information on Professor Stoughton's testimony in this area? Or could you have reread to us Mr. Gannon's testimony in this other area? Though there are no transcripts, still at times you can get the court reporter to read back portions, but that would be a tell. Why are they asking for this witness and not some other witness?
Interesting. Joe Tamburino, good to have you with us. Folks, we'll replay through the course of the day parts of the trial, things that were important, and more parts in their entirety here on CBSN Minnesota, along with the day's news and updated forecast as well. The other thing, Joe, that we didn't talk about, I guess we finally should. You know, today's the 20th of December, and Friday is Christmas Eve. They have a lot of incentive to get this done in the next 3.5 or 4 days.
Absolutely they do. And they could do it. I mean, 3 days of deliberation, 4 days of deliberation, that's quite a long time. I'm sure they'll have it done by then.
All right. Well, you will see us on CBSN Minnesota, and you will see us on WCCO TV as well, I would imagine. But we'll make sure we get you the latest information and through our social channels as well when the jury decides they come back with a verdict, assuming they do. You are watching our coverage of the Kim Potter trial in the case of Daunte Wright.